Next case on the docket is Wintergreen versus Consolidated-TOMOKALAND. Okay, you may begin.
May it please the Court, Beverly Pohl and Linda Spalding White from Broderick Cassell for the appellant Wintergreen Advisors. You know, for everything that took place in this case, 6 days of trial and a very lengthy final order, it really boils down to an interpretation that's never been made by this court, never very thoroughly by any court in the state of Florida, and that is what does Section 607, 1602, 2D mean when it says that a shareholder of a corporation has the right to inspect, quote, any other books and records subject to a few prerequisites for making that request. Any other books and records. Now, there's no basis in the text of the statute or in the history of the statute to read that phrase narrowly, nor is there any basis in the case law to read that phrase narrowly. Decades of case law dealing with shareholders' inspection rights have supported a very broad right of inspection, and if anything, this new statute, it's not so new anymore, but the current statute, which has been in effect 20 years and containing this very broad language, broadened the previous rights, because in the prior statute, a shareholder had to have a certain amount of ownership before it could make certain requests for inspection, and that was eliminated. And at the same time, this provision, any other books and records, was added. It's not in the Model Act, and it's not in the Delaware Act, and it's very dangerous to look at authorities from other jurisdictions when construing this. This is a Florida statute. What did the Florida legislature mean?
Isn't it a Model Act?
Not this particular subparagraph of the Act. I mean, it adopts portions of the Model Act, but it doesn't contain any other books and records. The only
How is this portion different from the Delaware statute on the same topic?
The Delaware statute doesn't have this as a separately set out item of things that are allowed to be produced in the same way that the Florida statute does. The only case in Florida that's looked at this is the 3rd District case, Computer Solutions, and it gave quite a broad reading and was dismissive of prior case law that gave a somewhat narrower reading, saying those cases were decided under a different statute, and the court said we're looking at Section 2D in particular. Now, I think that there is a single error.
You have a good point there. One of the problems I have is that one of those little prerequisites that you glossed over is that the request be made in good faith. And after a 6-day trial, the trial court made findings of fact that your clients were not motivated by good faith, but to bully the corporation's management, to interfere with management, and made findings to that effect. And I'm wondering why that wouldn't be a reason to deny the request, since the prerequisite was not shown.
I have 2 responses to that, Judge Lawson. One is that the record simply doesn't support that kind of bullying conclusion, but more importantly, and I think this is the key legal error that is subject to de novo review and which colored the trial court's analysis of all of the evidence that was presented. And the trial court looked not just to this statute, but to the director's inspection statute, which uses slightly different language, and it says a director at any time may inspect books, records, and documents. And this statute only says any other books and records. And the trial court found that to be a significant and substantial distinction and said on more than one occasion in the order that the director's right of inspection was significantly broader. That, I believe, was a legal error. And once the court made that conclusion that documents were not available to a shareholder under this statute, then the court kind of did the analysis backwards and said, well, you're not entitled to documents. You should have known you were not entitled to documents, and therefore your request was not for a proper purpose and was not in good faith. it really ought to be looked at the other way. First of all, the statute doesn't exclude documents. And long ago, in 1937, I believe, in the Florida Military Academy case, the Supreme Court said a shareholder's inspection rights are very broad, limited only by statute. And this statute is not limited at all. It's very broad. Any other books and records, anything relevant to the two proper purposes that were alleged by Wintergreen in its request. One was to value its shares. And I don't think it's insignificant or irrelevant that Wintergreen owned virtually almost $100 million worth of shares in this company. So that was...
I mean, that's sort of legally irrelevant. The statute allows any shareholder to get documents. So, I mean...
It does, but I don't think it's totally irrelevant because all the cases talk about look at the facts presented. And these facts are not that this was an idle request, a troublesome request, a fishing expedition. This was a 26% shareholder of this company that had made almost $100 million investment and had reasons to believe or to have some concern about the value of its investment. And really that's enough to show a proper purpose for this request and that it was made in good faith. It was made after a couple years of discussions with the company. It was made after some dissatisfaction with what the company had turned over. Just because a shareholder goes to court and makes a request for documents, that doesn't mean it's bullying. It doesn't mean that it's in bad faith. It means that they are asserting what they believe to be a statutory right to get documents. The other proper purpose is related to what I just said, and that is because Wintergreen had some concerns about possible mismanagement of the company. And those concerns came from certain statements in the public filings that seemed not to be supported by the documents it had seen. And it came from the resignation letter of a former member of the board of directors. And that letter, this is a big record, so I'm going to refer the court to it. It's Record Volume 5, page 744, and that is James Jordan's resignation letter, which articulates a couple of concerns that he had that led to his resignation and prompted some of Wintergreen's reasons for its request. So I don't think any credible argument can be made that these requests were not made in good faith and for a proper purpose.
What about the particularity requirement? The trial court made some findings that the statute requires particularity, and that really they were asking that they go on sort of a wild goose chase, and it was just unreasonable.
The statute requires reasonable particularity. The very first request had 17 categories of documents, and they were as particular as could be, considering you don't know exactly what is there. You don't know exactly what you're going to be seeing. And the second request had substantially more particularity because it was responding to what they had seen.
Here's what it says. It says a corporation is not supposed to go on a wild goose chase to try and find some documents that nobody can describe. And this is especially true of a relatively small staff corporation.
There are two errors in that statement. One is that nobody...
Okay, go ahead.
One is that nobody can describe these things. By the end of the case, the parties at the court's request had constructed a very comprehensive spreadsheet. It's part of our appendix, tab 15 of our appendix, identifying each of the disputed items. So there's no question that these things were clearly described at the end of the day. Were they on day one? Maybe not. But you don't know exactly how to describe with precision what you're looking for until you see kind of the universe of what is there. It calls for reasonable particularity.
And then later on in the order it says that at the same time there were emails presented by the defendants show that Wintergreen had decided to play hardball. Which is fine if you have the right to play hardball. And in this case, they were playing hardball by demanding a huge number of documents that this court finds they didn't have the legal right to request. So, I could go on with some other findings in the order, but it just seems like the trial judge was impressed by the fact that Wintergreen was trying to take undue advantage of with these huge requests. It's not stating them in particularity. There was a finding that they weren't made. A lot of them weren't made in good faith and that sort of thing.
All of those findings, not made in good faith, flowed from the notion that they were not entitled to documents. And that's why I say I have to bring the court back to that essential question, because if that's wrong, if that prerequisite for the court's analysis is wrong, and that in fact any other books and records encompasses documents and encompasses something more than the basic list of corporate records, and it must, otherwise it would have no meaning, then there cannot be any finding of bad faith, because they are entitled to see those things for a proper purpose.
And the support for your argument that the demands were made in good faith is based, number one, upon the former partner or shareholder of the corporation that stepped down and provided the communication with Wintergreen. But following that, was there any indication that there was any further impropriety that came up in the litigation, even with the first request? What I'm getting at is, I guess it was Winters and testified or provided testimony to the court that they found no evidence of impropriety as the document production was going through. Is that correct?
Well, remember, impropriety is not a prerequisite under the statute, not as a threshold for making the request, and not as for continuing the request. The Florida statute does not require us to show that we have some belief in impropriety. I'm just saying that the Jim Jordan resignation letter did provide certainly something that prompted some of these requests.
There was evidence by your own witnesses that they were good stewards of the money and the property and all of that, yet you persisted with these requests. Why couldn't that be a factor that the trial court could consider and say, well, they're just not acting in good faith?
Because we're entitled to these things. You know, this is...
what is exactly that you did not get that you say you're entitled to? I mean, we have trade secret issues and that sort of thing, but other than what's encompassed by the trade secret...
The primary trade...
What exactly is it that you say you should have gotten that you didn't get?
Well, there are a large number of things, and the court does deal with them number by number in the order, and they are identified on the spreadsheet that's at tab 15 of the appendix.
What do you say you did not get that's not encompassed by the trade secret part of the issue? I mean, other than that, what do you say you...
A lot of reports that had been shown to the board of directors, reports about compensation, leases. You know, it was represented publicly that the leases were operated as a hedge against inflation because they had escalation clauses. But when at least some of the leases were examined, they had no escalation clauses. And so these kinds of things, the fact that certain representations were being made publicly that were not backed up by the documents, that's what we wanted to see. Give us the backup of that. But let me turn to the trade secret issue, because this was very key to what one of the things that Wintergreen wanted. And remember, Wintergreen wanted to value its stock. It owned $100 million worth of stock. And CTO said...
Let me just back up a little bit, and I know you want to get to trade secret, but under the Computer Solutions case, they said previously we, the third district, have said if you're trying to value the stock, you're limited in the kind of documents you can get, and there's a list of those documents in Mandel from the third district and Sage. Did you get those documents?
We got those documents, okay. But remember, if you look at the Mandel case, there's language in the Mandel case, I don't have it right here, that says nothing further besides those things was even asked for. So the Mandel case doesn't stand for the proposition that that's all you get under any circumstance, and the Mandel case even acknowledges that you have to make some additional showing why you may be entitled to something more. Here, I think the showing was made with substantial evidence that was presented over the course of this hearing. But if I could turn to the trade secret issue, this was a model that the company that CTO described as its business plan. It purportedly used this model to make the decision on an annual basis or repeatedly that doing Section 1031 exchanges was the best business practice. We said, show us the beef, show us how the model works, show us what goes into it, show us the kind of data that you get out of it so that we can analyze for ourselves if the decision, the conclusions you're drawing from it support your public representations. And the court was so concerned because that was called proprietary and trade secret. And aside from...
Why isn't that right?
Well, for one thing, those defenses were not timely raised. They were not raised until the middle of the trial. But assuming for the moment...
Did you make objections to the trade secret issue? Are you, from what I understand reading the the briefs and the record here that there were no objections made.
Well, we objected in closing argument because...
Well, that closing argument's a little bit late, isn't it?
Well, it's a little late to raise the defense in the middle of the trial. It wasn't raised in their responses to the requests that we had made to them.
Well, there's such a thing as trial by consent. So if an issue isn't raised by a party, but it's tried by the parties anyway, it's called trial by consent. So you waive your, you waive your right to say, okay, well, it wasn't properly raised, and you waive that objection, right?
Aside from the
Isn't that what happened here?
Aside from the procedural objections, though, the trial court didn't make a full balancing test. It looked at how disclosure might harm CTO, but it never balanced that against Wintergreen's interest in seeing those things. And that is essential. Moreover, even if it were a trade secret, the court, under the statute and under the case law, has the
You're
power...
going to get into the in-camera thing, right?
Yeah, absolutely. Not only an in-camera inspection, but a confidentiality agreement, which the parties already had.
Well, did you ask the court to go back and make an in-camera inspection of all this and go back and tell us? Did you ask the court to do that?
I think they asked repeatedly for the court to do that, yes. I'm running into my rebuttal time, so I'd like to reserve the remainder of my time, but with one concluding thought, and that is, even if it were properly raised, even if it were actually a trade secret, there's nothing to suggest that a confidentiality order wouldn't have been sufficient to protect both parties' interests in this case, because Wintergreen was not an adversary or a competitor of CTO. It believed in CTO enough to make a substantial investment. It wanted CTO to succeed. So in these particular circumstances, a confidentiality order would have been
well, apparently this was,
appropriate.
apparently they thought that there was some adverse litigation going on, or requests being made, in that they thought that they were just being inundated with these requests, some of which they didn't think were appropriate, and so this wasn't really an amicable request, at least from their thinking, was it? I mean, they kind of thought this was kind of an adversarial proceeding, didn't they?
It may have felt that way because it was a big request, and I can't deny that it was a big request, but even if it is adversarial, if the statute gives it, then the court ought to have required it to be disclosed. And there are procedures worked into the statute to minimize the burden on the corporation. This is the age of disclosure for corporations, and any time there's a disclosure requirement, whether it's in civil litigation, shareholders' requests for information, public records requests to public agencies, it always feels burdensome, it always feels annoying, but it's got to be done, and there's no reason under the text of this statute that Wintergreen was not entitled to these things.
Okay.
I'll reserve the remainder of my time.
May it please the Court, my name is David Jones of Holland & Knight, and I represent the appellee and defendant below, Consolidated-Tomokaland Company. I'd like to start by focusing on an issue that wasn't addressed really at all by the appellant in their initial argument, and that is the standard review. As the Court well knows from the briefs, there is an issue of statutory interpretation, which obviously is something that this Court can examine de novo. There are also several factual issues in the case that Wintergreen continually attempts to gloss over, as Judge Sawaya, I think you recognized in some of your questioning. The standard with regard to the trial court's factual findings, which were extensive, this was a 35-plus page order entered after 6 full days of trial.
Let me ask you this. They sort of are correct in that the trial judge found bad faith or a lack of good faith in large part by saying they asked for documents when they were only entitled to records. So by asking for more than they were entitled to, they were harassing the company. So if the trial court was incorrect in the interpretation of the statute, then that would not be true. In other words, if records and documents are the same thing under the statute, then the requests weren't overly burdensome or harassing in terms of. So if you take that away, what evidence would be left of bad faith or lack of good faith?
I have to answer that in two ways. First of all, let me address the books and records versus documents issue. While the trial court clearly found that the category of documents was something other than and broader than the category of books and records, frankly, we think the trial court was correct on that point. As we pointed out in our brief, the statute within the same chapter, 607.1605, addresses the rights of directors to obtain books, records, and documents. The shareholder statute is restricted to books and records. The appellant in their brief suggests that records is a broader category than documents. And to support that argument, they cite the case of electronic data. Electronic data, while it's a record, it isn't a document until it's printed. Frankly, I think that's a disingenuous argument. In this case, massive amounts of electronic data were produced, and at no time did Consolidated decline to produce a single bit of information under the rationale that it was electronic and not paper in form. Secondly, this statute, in all the cases interpreting it, none of them deal with electronic data and get into the issue of electronic data is only a record until it's printed and then it becomes a document. Not one case cited by either side addresses that issue, and it doesn't make sense. In the context of the statutory scheme...
Well, you keep using the term official books and records in your brief. That's not what the statute says.
I agree, and I think you can eliminate the word official and it doesn't change the analysis. I don't think there's much dispute.
What about 607-16033, which talks about how much the corporation can charge the shareholder for the documents produced to the shareholder? And it uses the term documents. Doesn't that suggest that the legislature intended records to be sort of synonymous or interchangeable with documents?
I don't think it does. That section, as Your Honor correctly points out, has to do with allocation of cost. It's not dealing with a substantive right on the part of either the shareholder in the case of subsection 1602 or the director in the case of 1605.
The second problem I have with your argument is if you just go to a dictionary, Black's Law Dictionary, and look up records, it's a very broad definition, including documents and other kind of things. So
I agree.
So the common usage wouldn't be as narrow as you're saying. And then I guess the third problem is that at common law, a shareholder had a right to all documents, basically. And the law is that a statute isn't construed as sort of doing away with common law unless it clearly does so, and just that little change in wording wouldn't be a clear change. So I'm sort of struggling with your argument.
Let me make just one more point on the books and records issue, and let me go to the other reasons that the trial court ruled the way it did, as set out in great length in the order under review today. The other thing is I think records, as opposed to connotating a distinction between paper and electronics, the point that we try to make in our brief and the point that I believe the legislature intended is that records implies some level of formality that documents doesn't. A piece of paper with one word written on it can be a document. I don't think anybody can seriously contend that it's a record. And the trial court analyzed that issue, I think, quite cogently and quite correctly.
But counsel, in kind of along the lines of what Judge Lawson was getting at, 607-1603 sub 3, right after the sentence where it says corporation may impose a reasonable charge covering the costs of labor and material for copies of any documents provided to the shareholder, it says the charge may not exceed the estimated cost of production or reproduction of the records. In that, with those two sentences together, isn't the legislature treating documents and records as one and the same?
I would suggest that it's sloppy drafting. I mean, if you look at the key sections here, they are the statute that governs the shareholder rights and the statute that governs the director's rights. Under the director's statute, it includes the word documents. Under the shareholder statute, it doesn't. Otherwise, they're very similar, and I think the words are relatively plain when read in that context. But more importantly, the appellant takes the position that this books and records issue was the thing that drove the train. And I suggest that that's not the case, or this order under review wouldn't have been 35 pages long. The part that the appellant glossed over at trial and is glossing over on appeal is that the shareholders' rights are not infinite. The shareholders' rights are specifically defined by 607.1602. With regard to any other books and records, and for the sake of argument, let's even engraft the word documents on there while I'm not conceding that point, before they're entitled to anything at all under 607.1602. They've got to show, A, that the demand was made in good faith. On the good faith issue, while the trial court did in part rely upon by asking for this vast universe of documents as opposed to books and records, he also made specific findings. He found, in his own words, the internal emails within Wintergreen immediately preceding this document request to reflect a hostile and bellicose attitude. He cited instances in which they internally said, we're going to have this company building tall buildings and owning them. We're going to stop them from selling all land. They're not doing what we want them to do, so we're not going to play softball any longer. The beef here, despite counsel's representation that they were concerned about mismanagement, frankly, that contradicts the record. I personally asked Mr. Geary, the Wintergreen analyst who testified at length at trial, are you alleging mismanagement? And he said, no. We want to see if it's properly managed, but we don't have any basis for accusing the company of mismanagement. And while they claim that Florida law, unlike perhaps Delaware law, doesn't engraft a requirement that in order to obtain materials from a corporation for the ostensible purpose of seeing whether the affairs of the corporation are properly managed, each and every Florida case, Delaware case, and any other state that I could find, while it may not have come out and said that that was a requirement, the facts in each and every one of those cases evidenced a basis for the shareholder to suspect fraud, for the shareholder to suspect improper purpose. In one case highlighted heavily by both sides, the issue was whether the corporation, it was a quasi-public corporation that owned a hospital, and there was a real estate transaction whereby the hospital might be used for something other than serving indigents. A shareholder said, that contravenes the purpose of the corporation, and I want to see all the documents on this deal to see if and when this deal gets consummated, this hospital is still going to be used to serve the indigent. The other cases involved instances where in a closely held corporation, a director and officer called a meeting contrary to the bylaws of the corporation and froze out the party seeking documents, who then wanted to find out what happened at that secret meeting. They involved cases of insider dealing. They involved cases of fraud. None of that is even alleged here, much less proven here, and they conceded at trial that they didn't even have a basis for alleging it. So the trial court really didn't hang its head on while it analyzed, and I suggest correctly analyzed, the books and records versus documents issue. The court also went at length down the requirements and found that this demand was not made in good faith by virtue of the we'll have them, building buildings and owning them. Let me touch for a moment on the resignation letter of one of the directors that they cite as the basis for their concerns. That director resigned for two reasons. One, the same thing that Wintergreen was beefing about in these internal emails, and that is that management, in Wintergreen's opinion, was not open to new and different business models. That is a classic difference of opinion, and frankly, a shareholder, even a $100 million shareholder, doesn't have the right to dictate the business plan. And I don't think counsel could get up here and credibly suggest otherwise. So it was this combination, but back to the resignation letter, there were two reasons this director resigned. One, disagreement, didn't think the board and management was open enough to perhaps expand their business horizons. And the second reason is the company refused to postpone a shareholders meeting at which one of the issues was the election of directors. Wintergreen conceded at trial that it made that request long past the publicized time for putting issues on the agenda for the meeting, and conceded that it was within the company's discretion at that point in time not to cancel the meeting, renotice it, reschedule it. So even the letter that counsel cites doesn't indicate mismanagement in the sense of wrongfulness, illegality, impropriety, self-dealing. This was a difference of opinion on business issues. Let's go to the next qualification in the statute. Beyond good faith and proper purpose. So let me touch for a moment. on the economics issue. In addition to claiming that they just kind of wanted to grade management's papers, which we don't think is a right that is a proper shareholder purpose, absent some facts that would give them a basis for being worried about it. The other ostensible basis or stated basis for the document request was to enable them to value their shares of stock. Counsel spoke to the Computer Solutions case. It's cited in their brief. That case, Judge Lawson, as you correctly observed, specified the categories of documents, and counsel conceded all those categories of documents were produced. There's a second issue here as well, and again, one that Wintergreen seems to conveniently gloss over, and that is in all those cases that seem to give a relatively expansive right to the shareholder to get financial information for purposes of valuing its stock, they were privately held corporations whose stock wasn't traded on a public exchange. As the court pointed out, CTO has massive financial reporting requirements, all of which can be available with the click of a mouse on the SEC's EDGAR website.
Computer Solutions, the court did say that in addition to the documents we've previously recognized you're entitled to assess the value of your shares, if you show a need for additional records, documents, in order to assess the value of your shares, you can get those as a shareholder.
I agree. The case says that. However, number one, what additional documents? Counsel didn't mention any here today, and their brief doesn't specify any documents that they claim they need but didn't get for the purpose of valuing their shares. Secondly, let's look at what they did get, all of which is in the record. They got the financial statements, the balance sheets, the profit and loss statements, the expense reports. They got the general ledger. They literally got the document that shows every penny, transaction by transaction, going into and out of the company for the entire time duration of their request. Counsel said that they didn't get leases. That's not true. They got every lease. They got every document from every closing of every real estate transaction CTO entered into over the subject period, whether it was a purchase of land, whether it was a sale of land, or whether it was a donation of land. They got all of them, each and every one of them. What else do you need, even under the Computer Solutions test? So that I think addresses the shareholder purpose issues. The trial court said with respect to mismanagement, there's no proof of it. With respect to valuing your shares, you got everything. The trial court, in fact, went above and beyond that and said that CTO had gone above and beyond the requirements of the statute in terms of both the magnitude of its production and the subject matter of its production. As Judge Sawaya correctly pointed out, it was only after the second request, which, by the way, in their brief they say we didn't respond to. That's not accurate. We didn't permit a second on-site inspection, but significant documents, as evidenced by the record, were produced in response to the second demand. They suggest that the trial court's analysis was, quote, colored, close quote, by this books and records versus documents issue. I think I've addressed that. The court made specific factual findings to support his position that many, if not most, of the document requests were made in bad faith. And those factual determinations were based upon his review of the evidence and his analysis of the demeanor of the witnesses, and because he was in a position to do that and this court isn't, that's the whole reason why the trial court's factual findings, which are extensive and detailed, are entitled to a presumption of correctness that I don't think the appellant has come even close to rebutting here. To stand here with a straight face and say there was no substantial competent evidence whatsoever to find bad faith in light of the trial court quoting the testimony and quoting from the emails that we argued was indicative of bad faith, I don't think makes the grade or comes anywhere near meeting the burden that is on the appellant in order to try to convince this court to reverse the trial court's findings. Counsel said this wasn't a fishing expedition. This was, while an expansive request, a very heavily targeted one. I won't belabor this point. The trial court ruled and said why he ruled that the requests were incredibly broad, incredibly vague, and subjected the company to going off on a wild goose chase to find documents that nobody seems to be able to describe. Let me just read from paragraph 1 of their initial request. Documents. For purposes of this letter, the word documents is defined in the broadest possible terms and includes electronic records and email related to CTO's day-to-day financial operations over the past 3 years, including but not limited to any and all financial statements and documents showing CTO's cash expenses categorized by type of expense. They go on in that vein. Frankly, in document discovery, in a typical piece of civil litigation, the right of a party to seek documents from an opposing party, as this court knows, are very expansive. It's basically you can ask for anything and everything that is reasonably likely to lead to the discovery of admissible evidence. The standard here is stricter, and it's the one delineated in 607.1602, good faith, proper purpose, reasonable particularity of the request, and the records requested are directly connected to the shareholder's purpose. I suggest that's a higher bar, and that these requests wouldn't even pass muster under the lower bar under request for production in a typical piece of civil litigation. So this was indeed a classic fishing expedition. And in fact, if you look at the last category in their initial demand, all internal memoranda, analyses, and presentations that relate to any of the foregoing items. They argued at trial that that paragraph is the one that entitled them to a document that was the subject of a great deal of controversy at trial, the infamous Towers-Perrin report, which was an outside consultant hired by Consolidated to analyze its executive compensation structure. As was indicated in the record by a letter that we put into evidence, the former chairman of Consolidated Tomoka wrote a letter to Mr. Winters long prior to these document requests ever being made and long prior to the litigation, and in which he referred to the fact that CTO had commissioned Towers-Perrin to do this report. They knew about it. This thing that they were as specific as we could possibly make them was demonstrated beyond a shadow of a doubt at trial not to be the case. They knew about this before they sent the initial request. And yet at trial, they said this catch-all, any and everything related to any of the foregoing, was the request that should have required us to produce the Towers-Perrin report. I see my time is short, so let me talk a minute about trade secrets in the model. As the trial court recognized in his ruling, while he chose to get to the trade secrets analysis, he didn't have to unless and until he found that this model was something to which Wintergreen was entitled under the statute. I would suggest to the court that even under Wintergreen's interpretation of the statute, a software program into which you input data and you input various assumptions that you can tweak at will in order to test drive different things, that's not, under any stretch of the imagination, a document, a record, or a book. That's a software program. And what they wanted to do is grade each and every decision management made to make hay out of it. One last point, since I have 13 seconds, I would just like to remind the court that we timely filed a motion for attorney's fees on appeal, which we concede is contingent upon the trial court awarding us fees at the trial court level. And for the reasons stated in that motion, should this court affirm, we ask that you also include in your opinion direction of the trial court to award fees on appeal should he choose to award us fees at the trial court level. Thank you very much.
Thank you.
Point out that in CTO's
Let me ask, when I asked you before, what documents did you not receive that you had requested that you think you're entitled to, and you honed in on the leases and some of the closing documents. Opposing counsel said you got all that. Is he wrong?
Yes, he's wrong. I mean, just look at the order. The order identifies by document number on the spreadsheet.
Well, regardless of what's in the order, he said you got all the closing documents of all the closings that took place during the period of time that you made this request. You're saying he just was wrong about that.
We got closing documents, but I'm just saying there's a long.
Well, he said it included the leases too.
I don't believe that we did get all the leases, no.
Well, he's saying that you did. You know, or
I'd have to check and follow up, Your Honor.
What else are you saying you're entitled to that you did not get then?
If you look at the order, there are only 3 things that he said we did get. Every other disputed item,
Well, I know, but
we
when
did not get.
Maybe I misunderstood you, but and I'm not trying to argue with it, but I thought I asked you before, what are you saying you're entitled to that you did not get? And you honed in on the leases, and that was really your primary point. You wanted the leases, and you wanted those documents so that you could make your analysis. And he indicates that you got all that, and now you're telling me you're not sure whether you got it or not.
We did not get virtually everything that was in dispute on the chart that's attached to tab 15. There was only 3 things that he let us have. Let me say the key thing is the model and the input and the output to the model. We don't want them to give us their computer program that we can run on our own computer, but we want to see the analysis that they made of the land that they own, because that is very relevant and essential to valuing the value of the shares that Wintergreen owns. I'd like to point out that what the essential problem here is that the trial court didn't like this statute. At page 526 and 527 of the transcript, the court said, if the legislature could sit in here with us, I think they'd fix it. It's silly to give a single shareholder, and I have different feelings about somebody with a substantial interest.
Didn't they, when I read this, I got the impression that the trial court came to the conclusion that really what you had here was a 25% shareholder that was trying to flex his muscles and say, do what we ask you to do and follow our advice. Otherwise, you're going to be subject to this sort of request for documents and records and litigation and all of that. It seems to me like when I read the order, that's basically what the trial court was basically getting at.
But underlying that conclusion was the notion that they didn't get documents. If you read the order, every category that the judge discusses at the end of the order is prefaced with, this is not a document, they were not entitled to it, it was bad faith to ask for it. So by starting from that position that was legally erroneous, this case needs to be reversed and remanded so that the request can be reconsidered under the proper broad standard, because what the court did here has no basis in the statute, and it's contrary to what the legislature intended when it enacted any other books and records.
Okay, thank you very much.